Hello friends, I am Manoj Ram. Today we are going to see the Hindu newspaper yesterday editorial, a judicial pushback to a draconian legal regime. Friends, before seeing the editorial in detail, let me explain you the main subject of this news briefly. Students released after court rejects Delhi police stand. Friends, I think you remember the last year there were massive protests against the Citizenship Amendment Act. More number of students, social activists and social workers are also participated in this protest. But unfortunately, last year in North Delhi, this peaceful protest later turned into a communal riot. Several persons died in this riot. The Delhi police arrested them under the Unlawful Activities Prevention Act. The main objective of this act is to counter the terrorism. Now, after 1 year, day before yesterday, this matter came before the Delhi High Court, and the Delhi High Court, after inquiring into the matter, granted bail to those persons who are in jail for committing these communal riots. The Delhi police are not satisfied with this High Court judgment, and now the Delhi police are planning to appeal to the Supreme Court. Friends, in this editorial, the author has talked about the strict nature of bail provisions under the Unlawful Activities Prevention Act. The author has also raised major concerns about the Delhi High Court's judgment. Friends, before seeing the bail provisions in detail, let us have a overview of the Unlawful Activities Prevention Act. Okay. In 1962, between India and China, the war was going on, and at that time, subsequently in 1962, a speech was given by our former Tamil Nadu Chief Minister Annadurai in Rajya Sabha, demanding Tamil Nadu as a separate country. These two issues are going. Now, if any country which is attacking us externally, we have that provision Article 362 to declare our country as an emergency. So, we can deal with that provision. But if any region is demanding for a separate country, so at that time we don't have any specific law to control their speeches or any other actions. So, this made the central government to form the National Integration Council to address the problems of integrity which in matters of casteism, communalism or regionalism. So, in these matters the National Integration Council will address the problems. So, this National Integration Council in 1967 made a recommendation to the Parliament, and with this recommendation only the Parliament enacted the Unlawful Activities Prevention Act in 1967. Friends, now let us have an overview of the terrorism legislations in India. The Unlawful Activities Prevention Act was originally passed in 1967. At that time, the act was introduced to prevent any unlawful activities involved in separation of cession of territory and not dealing with the terrorist activities. Friends, now we have to note that after the enactment of the Unlawful Activities Prevention Act, the act was firstly not dealing with the terrorist activities, and after that 2004 amendment only, this Unlawful Activities Prevention Act was dealing with the terrorism activities. Now, after this act, the next legislation is Terrorist and Disruptive Activities Prevention Act, TADA, was passed in 1984 to prevent terrorist activities and any movements demanding for a separate country, and this act was repealed in 1995. Friends, as you know, more number of movements in between 1984 to 1995 came and they demanded for a separate country, and which is against our India's policy of integrity. So, at that time this act was introduced, and this act provided more number of powers to the police officials, and the police officials, if they think any person as a terrorist, without any thinking they can arrest without any reason. So to curb that powers only this act was repealed later. And coming to the next legislation, which is the Prevention of Terrorism Act, POTA, in 2002 was also meant to prevent terrorism, and which was also repealed in 2004. The reasons for repealing these two acts are the same. After repealing these legislations, Parliament gave more power to the Unlawful Activities Prevention Act by giving an amendment in 2004. In 2004, the Parliament was amending the Act, Unlawful Activities Prevention Act. The Parliament was amending that Act, and that amendment added Terrorist Act to the list of offences. Now only that the word terrorism is coming to that Unlawful Activities Prevention Act. The Act assigns absolute power to the central government, by way of which, if the centre deems an activity as unlawful, then it may, by way of an official gazette, declare it so. Friends, another one drawback in this Unlawful Activities Prevention Amendment Act is there. That is, this Act does not contain any comprehensive definition for the word terrorism and for the another word unlawful activity. So, if whether an activity is unlawful or is kind of a terrorism in nature, it is only the center, that is the central government, to decide that activity is terrorism activity or an unlawful activity. So, this brings a confusion for the investigating agencies to decide whether that activity is unlawful or a terrorist activity. So, there is a confusion in the definition. So, there is no definition, because of that confusion is happening. Yes. In 2008, after Bombay terrorism attack, National Investigation Agency under Home Ministry was introduced by the Parliament and allowed National Investigation Agency to handle the Unlawful Activities Prevention Act cases. An investigating agency can file a charge sheet in a maximum 180 days. Okay. So, now 2008 NIA is coming to the picture, and they are also given some powers to handle the Unlawful Activities Prevention Act cases. In 2019, Parliament cleared the Unlawful Activities Prevention Amendment Bill 2019 to designate individuals as terrorists. If the individual commits or participates in acts of terrorism, prepares for terrorism, promotes terrorism, or is otherwise involved in terrorism, okay, they have the power to arrest the terrorists who are involved in terrorism. Okay. The major concerns of the Unlawful Activities Prevention Act are: this Act does not have any comprehensive terrorism definition. So, it is upon the center to decide what acts constitute unlawful activity or terrorism. So, it is very difficult for the investigating agencies to decide which act constitute unlawful activity or which act constitute terrorism. So, it is very difficult for them to decide. So, without any proper comprehensive terrorism definition. Second one, the bail is very complex in Unlawful Activities Prevention Act. Because if we are charged in any other act, any other statute, the bail can be granted easily. But here the bail cannot be granted as a matter of right. So, this is the second concern. And the third one is the major power to police agencies backed by government. Here what happens is, if we are giving more number of powers to the police, this will amount to the citizens' infringement of fundamental rights and human rights. So, if the police are given more power, and they will be arresting any person without warrant, means they will arrest every person with their personal enmity. So, this will happen if we give more power to the police agencies. Now, coming to the bail under Unlawful Activities Prevention Act, Section 43 Class D, Subclass 5 of this Act, which prevents the release of any accused person on bail, on a perusal of the case diary or the report made under Section 173 of the Code of Criminal Procedure, the Code is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. In India, with our overburdened courts and creaking justice system, criminal trials take years, especially in high-profile cases such as Delhi riots case, where the records are bulky and the witnesses are in hundreds. Trials can take even more years, even a decade or more. Now, coming to the landmark case, Hitendra Vishnu Thakur versus State of Maharashtra. In this court, the Supreme Court has stated that terrorist activity does not merely arise from the disturbance of law and order of public order. Now, after the Supreme Court statement in this Hitendra Vishnu Thakur case, now the Delhi High Court is again reiterating that why the Unlawful Activities Prevention Act has been applied in the Delhi riots case. Here, the riot has been happened, where we can also apply, instead of applying this Unlawful Activities Prevention Act, we can apply that IPC, right? Where here in this riot case also, the public order has been violated. So, we can deal with this riot case with Section 141 of IPC under the Unlawful Assembly, right? Here where the public order has been violated. So, we can treat this with IPC rather than dealing with the Unlawful Activities Prevention Act. So, the right to protest is a fundamental right that flows from the constitutionally guaranteed right to assemble peacefully and without arms enshrined in Article 19 Class 1, Class B of our Constitution. Though right to protest is an fundamental right, but there are reasonable restrictions which we should assemble peacefully without disturbing the public or violating the public order. Now coming to the importance of Delhi High Court's judgment. The Delhi High Court's judgment indicates a pathway forward in the quest for finding a balance between citizens' civil right and the imperatives of anti-terrorism legislations such as the Unlawful Activity Prevention Act. Unlawful Activities Prevention Act are nowadays misused. Terrorism generally means indiscriminate killings which are maximum in destruction and sometimes which are backed by the state agencies. So these are the things which are discussed by the author. Thank you so much friends. Thank you so much for listening. See you in another video. Thank you.